Good evening. Welcome to Voting Rights in Upcoming Elections in Alabama, What You Need to Know. I'm attorney, voting rights educator, and community volunteer Michelle Clemon, your host and moderator for this evening's discussion. We are honored to have with us three people tonight whose work ties directly to voting rights and who can speak directly to the issues and questions you may have following recent actions taken by the U.S. Supreme Court and the Alabama legislature. They are Kim Bailey, President of the League of Women Voters of Alabama, Jatan Bosby, President of the American Civil Liberties Union of Alabama, and civil rights attorney and retired U.S. District Court Judge, the Honorable U.W. Clemon. After introducing our panelists, we'll provide a brief primer that contextualizes the conversation and then get into the conversation with our panelists. There will be a question and answer session following the conversation, so please drop any questions you may have in the question and answer section. We'll have someone monitoring it to make sure our best effort is given to answer as many questions as possible before the webinar ends. It should be noted as we begin that this conversation is to be issue-driven, not partisan-driven. It will be about the issues of voting rights, voter deterrence, and racial justice. This conversation is designed to educate its attendees. Facts will be brought forth. Use the information as you will to determine how you will move forward. Now for our introductions. Kim Bailey currently serves as the president of the League of Women Voters of Alabama. A longtime advocate for civic engagement, she has been involved with organizations including the Junior League, Leadership Tuscaloosa, Challenge 21, the Girl Scouts, and the board of Tuscaloosa's One Place, a family resource center. Kim was also a facilitator for the Ketterling Foundation's community politics workshops. She has been a member of the League of Women Voters of Greater Tuscaloosa since 2014 and has served in leadership roles at both the local and state levels. Kim was the Director of Information Systems and Digital Content when she retired in October 2022 from the University of Alabama System Office after 28 years of service. Thank you for joining us, Kim. Jatan Bosby Gilchrist. Jatan Bosby Gilchrist is a trailblazer who became the first Black woman and youngest person to lead the ACLU of Alabama as executive director in 2020. Since joining in 2015, she has advanced statewide initiatives in gender justice, criminal legal reform, and voting rights, playing an integral role in the Milligan decision that reshaped the state's congressional maps. Nationally, she is the architect of the ACLU's Southern Collective, which fosters collaboration across the South. With degrees from the University of Alabama, Birmingham and Northwestern, she is a TEDx speaker and a founding board member of the state's Civic Engagement Table. She was selected as one of the 100 leaders nationwide for the inaugural Obama Foundation Leaders Program in 2023. Thank you for joining us, Jatan.
Pleasure to be here.
Thank you. Great. U.W. Clemon. U.W. Clemon has been a fighter for civil rights for most of his life. The son of migrated Mississippi sharecroppers, he was born in Fairfield in 1943. At the age of 13, he witnessed an act of police brutality against a friend, which directly inspired his decision to become a civil rights lawyer. He is a product of the segregated Jefferson County Public Schools. At Miles College, he was one of the leaders of the 1962 selective buying campaign, which led to a confrontation with Police Commissioner Eugene Bull Connor. The following year, he worked with Dr. Martin Luther King Jr. in the Birmingham demonstrations and desegregated the Birmingham Public Library. He graduated from Miles College in 1965 as valedictorian of his class. With a law degree from Columbia University, he returned to Alabama in 1968 and entered the practice of law. For the next dozen years, he represented Black plaintiffs in major civil rights litigation against the Jefferson County Public School Board, United States Steel Corporation, Pullman Standard Corporation, and the city of Birmingham. One of the first two Blacks elected to the Alabama State Senate since Reconstruction, he chaired the Rules Committee and the Judiciary Committee. He and Governor George Wallace battled on several civil rights issues. In 1980, he was appointed by President Jimmy Carter as the first Black federal judge in the history of the state, with unanimous approval by the United States Senate. He was the chief judge of the federal district in the Northern District of Alabama, implementing a more inclusive jury plan and judicial workforce. His best-known case resulted in the enactment of the Lilly Ledbetter Fair Pay Act. Since his retirement from the federal bench in 2009, he has resumed the practice of law. His most recent cases include the Gardendale School case and the Alabama Legislative Reapportionment case. He has received the Judicial Award of Merit from the Alabama Bar Association, the John Pickering Award from the American Bar Association, the C. Francis Stratford Award from the National Bar Association, the Drum Major Award from the Southern Christian Leadership Conference, the Paul Robeson Award from Columbia Law School, and the Thurgood Marshall Lifetime Achievement Award from the NAACP Legal Defense Fund. In 2021, the UW Clemon Elementary School, a Jefferson County public school, opened just miles away from his family home in Wylam. Coincidentally, he's also the man I call Dad. Judge Clemon.
Thank you.
Thank you all for being here. And as I referenced earlier, what we want to do now is contextualize the historical framework in which we got here. So I'm going to share my screen and go to a PowerPoint. Great. So this brief primer on voting rights in the US. So this is a timeline you're going to see twice, once at the beginning of this presentation and then on the back end. But I'm showing it to you now to give you a point of reference for there being 4 critical timeframes to talk about when we talk about Blacks and voting rights in this country. The first time frame is from 1619 until 1865. The second is the period of Reconstruction from 1865 until 1877, the end of Reconstruction. The third period is 1877 until 1965 with the passage of the Voting Rights Act. And the fourth and final period is 1965 to the present. And briefly, with regard to each of these periods of time, from 1619 until 1865 is a season of complete disenfranchisement of Blacks in the South. They were denied the right to vote unilaterally. In fact, enslaved individuals were counted as 3/4 of a person for the purpose of reapportioning or apportioning congressional seats and determining direct tax liability. And that's where you get the 3/5 compromise. And in 1857, you had the Dred Scott case in which the Supreme Court declared that enslaved Blacks were not citizens of the United States and could not expect protection from the courts or the government on the issue of slavery. So next we come to this second time frame from 1865. The Civil War occurs from 1861 to 1865. And then in the winter of 1865, you have the beginning of, or the first of 3 amendments to the Constitution, which are called the Reconstruction Amendments. The first is the 13th, which abolished slavery except as a punishment for a crime. The next was the 14th Amendment, passed in 1868, which established citizenship for those born or naturalized in the US and conferred the right of due process and equal protection upon all citizens. And the final of the Reconstruction Amendments is the 15th Amendment, passed in 1870, which prohibited denying the right to vote on the basis of race, color, or previous condition of servitude. So the third period we want to reference is this period once Reconstruction ends in 1877 through 1965. During this period, Black political gains were undone, and Jim Crow became kind of the dominant law of the land here locally. There was a high percentage of lynchings in this season, public and private. And there were specific tactics used to suppress the Black vote, whether that's poll taxes, literacy tests, even jelly bean tests, where so many jelly beans were placed in a jar and people were asked how many if you can guess the number of jelly beans in the jar, we'll let you vote. We'll give you the right to vote. And also, obviously, probably the most damaging or the most threatening tactic was denying Black individuals in the South the opportunity to to work or gain employment if they tried to register to vote or if they tried to vote. So 1877 to 1965, we reached 1965, and it's the watershed moment for the rights of Blacks, particularly in the South, with regard to voting. And the Voting Rights Act specifically targeted historically discriminatory voting practices in the South that denied Blacks the right to vote. And Section 2 is regarded as the heart of the act. It's a national prohibition on any voting practice that discriminates on the basis of race. Now, I've taken these out of numerical order for a reason, because they kind of build on each other in this sequence. So the Section 2 is the core of the act. 5 says, requires states with a history of voting discrimination to get approval, pre-clearance by the Department of Justice before making any changes to voting laws. And states with a history of voting discrimination were states in the South. Section 4 contained the formula used to determine which states are subject to the pre-clearance requirement. And Section 3 requires any jurisdiction whose discriminatory voting practice violates the 14th or 15th Amendment of the Constitution to get pre-clearance from a court or the DOJ. So let's hop forward 48 years from the passage of the Voting Rights Act. Shelby County versus Holder in 2013. It's a landmark Supreme Court decision which held that Section 4, that part of the act that goes to the formula which determines which states to which pre-clearance rules apply, that determined that formula was outdated and thus unconstitutional. This had the effect of neutralizing the pre-clearance language in Section 5 until Congress devises a new formula. Well, to this date, Congress has yet to come up with a new formula for Section 4. And most recently, 2 weeks ago, in the Louisiana versus Calais case, the Supreme Court decided that the redistricting cannot be based on race, but it can be based on partisan interests. Current data and current political affiliation must show intentional discrimination. And that is how we got here. And I want to come back to this timeline for a second. So here are the takeaways you might have from this timeline. In the 407 years since enslaved Africans were brought to what ultimately became the United States, Blacks were enslaved the first 246 years until slavery was abolished through the 13th Amendment. Blacks were denied citizenship, due process, and equal protection under the law for 249 years until it was granted through the Constitution. Blacks were denied the right to vote for 251 years until it was granted through the Constitution in 1870. After the passage of the 15th Amendment in 1870, it took another 95 years before Blacks were federally protected from voting discrimination through the enactment of the Voting Rights Act of 1965. Blacks enjoyed the full benefit and enforcement power conferred by the Voting Rights Act for 48 years before it started being dismantled in 2013 with the Shelby County versus Holder decision. 61 years after the passage of the Voting Rights Act, it's legitimate to ask whether it is only a law in name, with the sections crucial to its enforcement having been severely maimed by the Supreme Court decisions over the last several years. So that's setting the table for this conversation. And I want to get to asking the panelists now. Let's have a conversation about everything that's been going on. And first, I want to ask, what impact did the passage of the voting rights have on the electorate, particularly Black populations in the South?
Well, I guess I should answer that directly because I'm a direct beneficiary of the Civil Rights Act of 1965. When I graduated from college, there were no Blacks in the Congress of the United States. In fact, no Blacks in the Alabama legislature. Blacks were basically out of the political process. My third year paper in law school was entitled Redistricting in Alabama, the Unfulfilled Duty. Well, that duty is still unfulfilled. I was, because of the Civil Rights Act, elected to the Alabama State Senate in 1974. So that was one of the direct effects of the Civil Rights Act of '65.
Okay. Kim or Jatan, any less reflections, but just historical context you want to provide for your knowledge around the impact that the law had on Black populations throughout the South?
Sure, I'd like to jump in here, but really, Michelle, all I am going to do is re-emphasize the incredible historical context that you gave. We understand that the VRA ultimately was built to fully enfranchise and safeguard Black voters in the South. And what is ironic but not unfamiliar is that the two cases over the last decade and a half that have essentially stripped those rights came out of Alabama. It was Shelby v. Holder, in which essentially the Supreme Court named that we were in a post-racial society, no longer needing the federal government to dictate or to help or to ensure Black voters got to the polls. Ultimately, what we saw was a reverberating effect in which Southern states quickly implemented voter ID laws, shifting polling places, and doing things to ensure that they were stripping the rights of Black voters, particularly in rural communities. We saw that really take shape with the closing of many DMVs in the Black Belt. And then nearly a decade later, we are seeing the impacts of what that looks like. And I say two of those cases, although Calais was out of Louisiana, the Milligan case is what made way for Calais to even happen. And so when we're seeing these reverberating effects on what the Supreme Court is doing, essentially stating, because they essentially stated in Calais, that we are in a post-racial society, it really goes to show full enfranchisement of Black folks is only 60 years old. And so the fact that the VRA has been a safeguard is so foundational in what we have to understand about Black political power and what the backlash of Black political power looks like when we do not have these safeguards that are articulated in our Constitution and through federal protections for our communities, particularly Black folks in the South.
Great. Thank you for offering that, Jatan. And I want to have a follow-up question. So Shelby County versus Holder.
Before you do that, I think it's important to remember that the Voting Rights Act comes out of Alabama. It was Selma that produced the Voting Rights Act in the first place. And then with respect to Section 2, it was a case, Bolden versus City of Mobile, handled by Jim Blacksher, who's one of the lawyers for the Singleton plaintiffs right now. That interpreted, that case went to the Supreme Court. Supreme Court said that you had to have intent to prove a Section 2 violation. Jim and his folks changed the law, and Section 2 then focused on the effects, because Section 2 deals with dilution of Black votes. And so it's important that Alabama has always had a very important role in the jurisprudence of Section 2.
Okay. Thanks for that additional context. That's very helpful. So Jatan, kind of as a follow-up, and perhaps for those attendees in the crowd to get a sense of how stripping away pre-clearance really opened the door to get us here, right? After Holder, states began what we might describe as engaging in voter suppressive tactics, the voter ID requirements. Is it correct to say that before Holder, a state could not have implemented a voter ID plan without getting the pre-clearance from the DOJ? Is that accurate, or?
And this is what my understanding is, and Judge Clement, I think you can correct me. The entirety of the VRA, if you really look at it, and I learned this as I was continuing to learn about the gutting of Section 5, it was very specific to states that historically had disenfranchised Black folks writ large, whether that was a deep history of enslavement, a deep history of Jim Crow. And so absolutely very specific states historically would not have been able to do that, but for pre-clearance. Pre-clearance opened up the gateway for there to be provisions to ensure that you were enfranchising a very specific community, and that happened to be Black folks in the Deep South. And so I think the historical context itself, the answer to your question, as I understand it, is absolutely. And that is why we are seeing so much voter suppression in the Deep South. And folks like to say that, truthfully, the South is not red. If we are talking from a partisan standpoint, it is deeply suppressed, it is underinvested in, and it is deeply gerrymandered. And that has come by way of the gutting of various protections that have historically enfranchised Black folks that, to your point, for hundreds of years and for many generations, did not have the right and the opportunity to be part of the public.
Great. So we've talked some and set the table around what the VRA was supposed to do, the historical context for it, why it was about assuring the enfranchisement and any barriers to access to voting for Blacks in the South who has historically been denied that right. So now let's come to modern times and talk about just, it's been 2 weeks to the day since Calais dropped, if I'm not mistaken, and the Alabama House of Representatives voted last Wednesday to redistrict, and then the Senate voted favorably as well on Friday, and it was signed into law later that day. And so we've kind of had a flipping, it feels like a twinkling of an eye, we've had this shift occur. And I'm just wondering about all three panelists' initial reaction to where we are in this moment.
Well, as a legal proposition, we are before the three-judge court, which declared the 2023 legislative plan to be violative not only of Section 2 of the Voting Rights Act, but also of the 14th Amendment. That plan and the districts that were created by the court are the districts that will be in effect next week. So the election goes on under the court-ordered plan, and the Supreme Court's stay, sending the case back to the three-judge court, is now going to be addressed by the three-judge court next week. The Milliken plaintiffs filed a motion for a temporary restraining order. The Casper and the Singleton plaintiffs joined in that motion. We will all tomorrow file a motion for a preliminary injunction. The state has to respond to our motion by noon on Monday. And we have 24 hours, noon on Tuesday, to reply to what the state says. That's where we are legally. Also, the three-judge court has ordered the Secretary of State to explain by noon tomorrow exactly what he's proposing to do. But it's important to remember that the election next week goes on as scheduled.
As scheduled. And so let me take that a step further just to clarify. So am I understanding that to mean that for anybody who had already submitted an absentee ballot before Calais, before the action of this taken by the state last week, their ballots are not imperiled by virtue of for the primary
Yeah.
next week.
Absolutely.
Is that accurate?
As it's absolutely correct. The absentee ballots that have been cast, whether they were before Calais or after, as ours were, will be absolutely valid, will be honored, and they are good votes, absentee votes that have been cast.
Okay. Jatan, I wasn't sure if you wanted to hop in on that or not.
If Kim wants to jump in, and then I'm happy to
Okay.
give some time.
I was just going to say, yes, the election continues, and this is just sowing such chaos. People don't know what to think at this point. And so, yes, those ballots will count, but it is my understanding that if you are in one of those affected districts, your vote will be vacated. And so you will be voting again, perhaps. Again, so much uncertainty, right?
Well, let me correct you on that.
Okay.
The state wants to vacate the ballots, but we're fighting with all our might against that. We have asked the court to enjoin the Secretary of State from having that election in August.
And so it is unfortunate, I think, certainly from the league's perspective, because we want everyone who is eligible to vote and to understand that the press conference and all of these announcements and already setting a date for a special election is just confusing people. They don't know what's happening, when it's happening. And so it is, and I think that is part of the whole plan, really.
Yes. Well, let me say that it's another example of the tremendous disrespect that these state officials have paid to the three-judge court.
Yes.
The three-judge court ordered the state to come up with 2 opportunity districts. The state legislature met and refused to do it. That's why the court had to issue its own plan. And the court took note when it issued the plan of how, in effect, disrespectful the state of Alabama had been. Now, the state of Alabama is acting as though the matter is not before the three-judge court, where it is. And it's confusing people, thinking that even if they cast a vote, that vote eventually is not going to count. So, reasonable people would say, well, why go to vote if my vote's not going to count in the end? But it's another expression of the disrespect that the state legislature has shown for the three-judge court and the work that it has done. And this is not just an ordinary three-judge court. This is a three-judge court, 2 of whose members were appointed by President Trump. And the 3rd member was appointed by President Reagan.
And the last thing I would just say about this is not only, in my opinion, is it disrespectful to the court, it's disrespectful to the citizens of Alabama.
Thank you both for that. And Michelle, if I could jump in.
Absolutely. Absolutely.
So I would love to just give a bit of a framework here.
Sure.
There are 2 specific pieces of legislation that were passed last week. The first is SB 1, which allows for potential special election in the state Senate maps, 25 and 26. And I want to name something because to build off of what Kim said, it is disrespectful to Alabamians because that election with SB 1 specific to the state Senate maps would cost taxpayers $600,000. Additionally, HB 1, which we are very focused on, talks about allowing the potential new congressional primaries in congressional districts 1, 2, 6, and 7, if the Supreme Court lifts the current injunction, which they have essentially vacated and remanded to the lower court, the same court that they upheld the decision for in the Milligan case. And to Judge Clemens' point, It is now back in front of that 3-judge panel to make that determination as to whether they will uphold our temporary restraining order or respond to the court. Nonetheless, it is in front of the court. And what we're seeing is, if I'm using this correct, Judge Clement, and please correct me, they are preempting, which is why they keep saying this is what's going to happen. The state is. Ultimately, this special election that the governor has specified that's going to happen in August is going to cost taxpayers $4.5 million. And so when we are talking about the disrespect and the flagrancy of how you are approaching the legal process to essentially start the legal process, you're also talking about the disenfranchisement of Alabamians. And I think to both points, this is to put folks in chaos, to make them question, should I vote? We have to keep in mind that these ballots are not just including their state representatives or their congressional representatives. They are including everyone who is on the ballot, from governor to school board members to local electeds. That is who is on the ballot. It is not just your state legislative representative, whether that's representative or Senate representative or congressional representative. These are individuals that you have to look at your ballot holistically. And to tell people that your vote is going to be thrown out is deeply problematic. And I think that that's what we have to identify. Special elections specifically are for typically one seat, right? It is not that you are redoing your vote entirely. And I think that that's a really important point, especially as we see this play out in the courts. So I wanted to give that context of the two particular bills that were passed through the state legislature and exactly what they're saying. And so right now, people are taking into account what has been told to them by the Secretary of State, by the governor. But what we are emphasizing is that on May 19th, next Tuesday, folks have to go out and show up to the polls. They have to ensure that their voices are heard, and that is what is of the utmost importance. And we will see how the things play out in court, because that's why we have a incredible group of national and local attorneys working to address this, because they know what's at stake is, one, what voters need. Misinformation is taking hold, and the ability to ensure folks have the power of the vote, irrespective of folks who are trying to actively suppress it. And that's what we're seeing from our state government.
And as a follow-up or related point, perhaps even question, so as I understand it, that one announcement that came from the state this week that for this possible special election in August, it would, well, not so much with regard to that, but with regard to ballots submitted for this upcoming Tuesday or on this upcoming Tuesday, that for certain congressional districts, those votes might be voided. For districts, I think and 1, 2, 6, and 7. And what do you have to say? What's your reaction to that? What do you have to say to lay people? Is that misinformation? Is that confusion? Is that yeah, a yes but no statement? Can you provide some clarification about what how someone should interpret that, and in the context of the ballot they submitted, if they live in one of those districts?
Well, I think the answer has to be that the state is probably lying, but it's certainly misleading again, because the only way that there will be an August 11th election is that the 3-judge court will allow it. And based on what the 3-judge court has already said and what has already been affirmed by the Supreme Court, we doubt seriously that the court is going to allow the election in August.
So, Judge, put another way, it's an effort to mislead, or it has the result, the outcome of misleading.
Yes.
Because it presumes facts, not only not yet in record, but facts that haven't occurred yet.
Exactly. Exactly.
Yeah, yeah. If I could segue for a bit, I know we've got a question and answer Q&A section coming up, where we'll hear from the attendees. But I wanted to pose this next question to both Kim and Jatan, and I know your organizations have historically platformed voting rights as like one of your signature interests and focuses. And I'm just curious your actions, reactions to all that's gone on over the last 2 weeks over this voting rights piece in Alabama, and how your organizations are equipping to move forward in this context, in this new context.
Well, that is what the league does, right? So we were founded, of course, as part of the women's suffrage movement, to educate voters, to make sure new women voters knew that to get out there and how important it was to cast their ballot. And we have continued that work for every eligible voter. It is the core of what we do. We are deeply troubled by this continued fight, and we are working really hard to be sure people understand, as we just said, it is critically important to get out and vote. We are focusing on voter education. If this does happen with the special election, it is my understanding that they are not required to, per the legislation, are not required to let voters notify where their polling location is. And so that will be one of our main focuses, is ensuring that people know where to vote if they have a new district.
I'm sorry, Kim, would you repeat that? Did you say, I want to make sure I understood.
Yeah, so if there is a
Yes,
special
if
election,
there's a special election, yes.
in the legislation, I guess it was HB1, there is no provision for voters to be notified of where their polling location is, right? So if they have a new location because they're in a new district, there is no voter notification required. And please correct me if I'm wrong about that, but that is my understanding from watching it. So that will be something that we will really be focusing on, is to make sure that voters understand where they're supposed to go, who their candidates are, all of that. That is going to be our focus, is ensuring that voters have that information.
Jatan, can you speak to HB1, and there's a part of me that's just candidly floored that could be the case. I should not be floored, but yet I find myself there. So if there is a special election, the state is not obligated to tell those who are to participate in the special election where their polling place is.
And Michelle, I would have to make sure that I am following up and looking at
Okay,
the passage of that bill in its entirety to corroborate that. I
right,
cannot effectively speak to that. And I want to be really cognizant because I don't want to further sow
sure.
kind of this anxiety with folks. But I do want to speak to what the ACLU is
Mhm,
doing. So
mhm.
there will absolutely be a follow-up to that. I also would like to share a bit of a illustrative way in which we are communicating this. And we have a post about what it means to be voting on May 19th on all of our social platforms. So I encourage folks to check that out. But generally, the ACLU operates in 3 ways. We educate, we litigate, we advocate. And those are the 3 ways in which we are approaching this particular issue. The first is litigate. So we are actively litigating. You all have heard that as of Monday, we filed a temporary restraining order in the Northern District of Alabama's federal court, asking this court to essentially uphold a temporary restraining order, considering it is now vacated or remanded to the lower court per the Supreme Court. And so that is an important part of this. And Judge Clement has laid out that timeline for you. The second is advocate. Our policy team was in the State House each and every day during that special election, getting a deep understanding of what SB1 and HB1 meant, particularly for voters in the state, how that is going to impact our special election, but in general, the general election season, from primaries to the general. How is that going to impact us? And that's really important as we are advocating for voters. Furthermore, one of the issues that we are seeing take shape is voter suppression, as always. And the ACLU is part of a larger coalition around election protection. So what we are going to do is be a part of the war rooms, essentially, or the control rooms that are going to be around the state, led by local folks and the Lawyers Committee. And we are encouraging people to call 866 our vote. Again, that is 866 our vote. What this election protection hotline does is ensure that we are taking into account all of the instances around the state where we are seeing signs of voter suppression. And because of the Calais decision, it is even more imperative now than ever that we document these things. And that informs, one, our advocacy and policy efforts, and definitely informs our litigation efforts to be able to put things on the record when we are litigating substantial things to essentially uphold what we are doing. And the last piece is educating folks in the community. And I'm simply saying it's the last piece because of how I explained these three ways in which we show up, but it is the most critical piece. It is one thing to be able to litigate in the courts, to do work in the State House, but we have to understand that decisions in the courtroom and decisions in the State House affect real people. And so showing up in community is critical for us. It's one of the ways that we were able to literally have hundreds of people showing up at the State House in conjunction with many coalition members, because we are educating people, we are informing them. And essentially, I don't use the word empower because people have the power. What we are simply doing is passing the mic and informing them of what power they do have. We are really removing that opaqueness of what the State House is, and we call it the People's House. And each and every legislative session, each and every election cycle, that is our job, is to ensure people know the power of their voice and how they're showing up. And more critically, I do want to name that I think that this is a time where folks are scared. And I've seen in the Q&A chat that folks are like, well, should I vote? And the truth of the matter is, yes, because what we would hate to happen is there is a decision that has changed ultimately what the next outcome is, and we have missed the opportunity to really show up and show out for May 19th. And so that is what I really want to inform people to do, is to encourage your community members to show up for the election primary. It is critical that we do that. And that's what we really want to be the focus as of now, and also encouraging people, if you feel your rights are violated, please don't stand idly by. Please engage 866 our vote, election protection efforts, organizations like the League of Women Voters, and so many others in your community that are focused on civic engagement, but most importantly, protecting your vote. So that's a general overarching way in which the ACLU is showing it.
Right. Thank you for sharing that. It's important for our attendees and for us to know how your organizations have strategized, how you're showing up in this moment. So we appreciate both you and Kim sharing how your organizations are moving forward in this front. We have a couple of questions. I do have a final question for you all, but I think what I'll do is pivot and ask a couple of questions that are in the chat or in the question and answer section. Is there any chance, one question is there any chance that the three-judge court could grant the TRO before Tuesday?
I doubt that. No, unlike the Supreme Court, which denied our due process right to be heard before it issued the stay, the three-judge court is not going to issue a ruling before it hears from all the parties. And that means that it won't issue a decision until the final brief is in next Tuesday.
So it should not be ruled upon before the TRO won't likely be in place before Tuesday,
Well,
if it's granted.
actually, um, we're seeking a preliminary injunction. A temporary restraining order ordinarily lasts for 15 days. But what we are seeking is what we had before the Supreme Court issued the stay, and that is a preliminary injunction. And since the three-judge court did not rule on our constitutional claim in Singleton, if it did, we'd be seeking a permanent injunction. But since it has not ruled on that issue, we're seeking a preliminary injunction.
Can you all speak to, there's a question in the chat, can you all speak to what was held, the holding in Calais, and how that ended up having this ripple effect throughout, not just Alabama, but we've seen it in Tennessee and in other states moving in the similar direction. Can you tell us, like, I know we're coming up on the hour pretty soon, but can we kind of hear how Calais gets us to this point where our state legislature is moving as it is?
The first thing you need to know is that in the Calais case, the Supreme Court said, and I'm quoting now, nothing in Allen, that's the Milligan case, nothing in Allen dictates a result that differs from the one we reach today. So it is saying that what it approved in the Milligan case is not affected by what's said in the Calais case. In the Calais case, the Supreme Court update or refined what they call the Jingles factors. And if you look at the new requirements in the Calais case, the three-judge court has already addressed each one of them. And so, as we say in our papers, the three-judge court should issue the same preliminary injunction that it issued before Calais came down, particularly in view of the fact that the Supreme Court in the Louisiana case, in the Calais case, says that what they say in that case doesn't change the result in the Alabama case.
And if I could build on that, Judge Clement, we are talking about racial gerrymandering, right? And the Calais case is this like pivotal point in discussing this. The reason the Allen case is different is because, yes, the maps that were drawn by the state legislature in 2023 that were ultimately deemed unconstitutional that was a factor. District 2, that was drawn by a special master, was drawn using traditional redistricting principles, ensuring that we were keeping communities together, meaning we were not cracking communities, and also socioeconomic factors. Congressional District 2 is about 47% Black. It is technically not a majority Black district by definition. It is a district that was drawn on traditional redistricting principles. And that is what makes this issue even more substantially problematic, is that the state is saying something else, knowing full well that that is not how Congressional District 2 was drawn. Judge Clement, I see you wanted to jump in here.
Yeah, you hit the nail on the head. The plan that was imposed by the court is a race blind plan. And that's what Calais says. The districts have to be race blind. The state concedes that the present plan is race blind. That is, it conceded it before the three-judge court. Then it lied to the Supreme Court and said that it's race conscious. But we meet that test.
Thank you. Another question in the Q&A, is it still an open primary? Just moved here in July and have heard differing answers. Jatan, you're nodding your head. I didn't know
But
if you
Kim
wanted
could
to
probably
react.
speak to this. Yes.
What's that? What's
Kim could
that?
also, Kim could probably speak to
Kim
this
could,
with.
awesome. Kim, still an open primary?
Yes, I'm sorry. What about?
The question from an
Yes.
attendee in the Q&A is it still an open primary? This is someone who just moved here
Yes,
in the last
it
year
is.
and she's heard differing
Yes,
things.
thankfully it is. At this point, right, there was a bill trying to close our primaries, but we do still, yes, have open primaries. So when you go to your polling location, you request which ballot you would like, Republican or Democrat. They will give you the ballot, you vote. If there is a runoff, then you may not cross parties at that point. So if you chose the Republican for the primary and there's a runoff, you can only vote in the Republican runoff.
Thank you for that, Kim. Another question in the group, the question and answer section. There was a news story today that the redistricting was passed on May 8th, which is less than 6 months before the election and therefore is illegitimate. Is that true?
That is what we're arguing.
Okay, that's the crux of the, okay.
Yes. So
That's the heart of the
that's
matter.
limited if you want to speak to that, but essentially that is what we're arguing. So that is why they've placed it in the news, because essentially that is what our motion is saying. Because it is less than 6 months. You are basically trying to, it's unlawful.
Judge, you have anything you want to add to that?
I agree that it is unlawful. We think that the constitutional provision is clear on its face, but to the extent that we don't have to refer a matter to the Alabama Supreme Court, we prefer to keep it in before the 3-judge court.
And this is just a question that's come up in my mind to ask you all. Speak to why majority minority districts and representation would be important. Why are majority minority districts important for Blacks who have historically been disenfranchised and underrepresented in the South politically? Except for this 48-year reprieve under the VRA.
Well, fair representation is a cornerstone of, should be anyway, a cornerstone of democracy. So without that, not everyone has a voice, and every voter should have a voice.
Well said, Kim. Well said. Jatan or Judge, you all want to add to that at all?
Well, without provisions such as or laws such as the Voting Rights Act, Blacks in the South particularly will have no representation in Congress like they didn't until here in Alabama until 1992, because the representatives, the white representatives, were unresponsive to the needs of the Black community. And while to be sure, white representatives can represent Black constituencies, in point of fact, in Alabama and elsewhere in the South, the white legislators simply haven't. And that's not just a problem of the past, it's a problem currently as well.
Thank you, Judge. Jatan, did you want to add to that?
Yeah, because I think this is an important question, and I always like to zoom out a bit because we're talking about majority minority district. Why do we even get to reapportionment? Why do we even get to redistricting? It happens because of the census. And in 2020, the census we were expected to lose a congressional seat. Why is that? Because they said that there were less people in the state. Alabama did not, meet the representation of how many congressional seats that we have, right? And that was the assumption. After the census happened, what they found that there was an increase, particularly in the Black and population and other people of color, by 27%. So prior to that, it was 14%. So that increase of 27% ensured that, like, oh, wait, we actually don't have the representation that we need. And that is why there is a reapportionment process to ensure that communities have the representation that they need. And that is, I think, not just the irony of it all, but that's an important underlying factor that gets breezed over when we talk about redistricting. It is quite literally the obligation to ensure that people are represented in community. Because why? Because I care about my utility bills. I care about the funding that is going to my schools and my community centers. I care about the fact that I want to be able to elect somebody that has my community interests in mind. And that is what it is about, my community interests in mind. What is specific to my community, what is specific to me, and people who are from my community that know my community being able to represent me at the legislative level and the congressional. And so to Judge Clemens' point, to the point that we've been making, and to Kim's point, it is about people having the ability to have their voices heard, right? That's what we have a republic, essentially, right? A democratic republic. And that is what it's about. That is the true form of democracy in action. And so as important as your question is, I want it to be very clear that ultimately redistricting is about representation. And you just don't show up here. You show up here because the numbers say that people need representation, and specific communities need representation because there are more of them here, and we didn't assume that they were, but now they are. And how do we ensure that we are elevating these communities, keeping them together, not diluting and cracking their communities where one person on one street is voting in one congressional district, and right across the street they're voting in another. That does not make sense. And that is why it's so important for us to articulate the necessity of keeping communities together when we talk about the reapportionment process. So the next thing that I want to say, and I'll wrap up quickly, is now we have to be focusing on 2030. Mm-hmm. Now what this is preparing us for is identifying how we ensure that we are not missing the opportunity in the reapportionment process to ensure our communities are together. And we did a great job of that in 2020, hence the Milligan case, but we need to ramp it up in 2030 because we are seeing the vestiges of what white supremacy looks like when power is being lost. And so that is a critical aspect of all of this and undergirds the importance of this movement.
Let me just say this about 2020. The state agreed before the three-judge court that it would leave the congressional lines just as they are under the present plan until after the 2030 census, unless the Supreme Court gave them permission to do otherwise. So the state has already agreed that it won't make any changes until after the 2030 census, unless the Supreme Court tells them that they can. And it has not, the Supreme Court has not told them that they can.
Thank you all. Thank you all so much. So I want to wrap up on kind of a call to action note. I think you all, the three of you have presented the case, given us the status update, told us what we're doing, what you're doing as organizations, as a part of this fight. So let's talk about what the call is, the call of action is for citizens who are concerned about protecting their right to vote and having to elect candidates that represent and will advocate for their interests. Like what can the average person do who's concerned about these issues? What would you advise them to do?
Well, my advice is vote every chance you get, particularly on May the 19th in that election. And in addition to voting, you need to urge your family and friends and everybody you know to do likewise. And you should participate in rallies and getting togethers and various community efforts to demonstrate how urgent this issue is.
So I would just say, of course, that's my message as well. Vote. I would say also be informed. And so we have a vote411.org with all the candidates' information about your where you vote, your district, all of that is on that website. I would say for voting, Alabama has an extremely low voter turnout, particularly in midterms. So let's change that. If we have enough people going out to vote, we can make a difference. That is the key. You do not like what these people are doing, they work for you. Your elected officials work for you. So hire someone else. Go out and vote and get everybody you know who is eligible to vote to go and vote. And let's get the voter turnout up, and we can really, really make a difference. The other thing I'll say, because this is a long game, right, is consider running for office. We need new officials. If you aren't happy with what they're doing, then maybe you can go there and make that difference, and really gives that some thought. Think about other people who might be really good in that position, and let's get more candidates on the ballot, because that will make a difference as well. Right now, so many times you go and it's just a single party that has candidates for a position. So let's change that too. And let's get out there and make a difference. And that is how it's going to happen.
Oh, I'm so sorry. So calls to action. I'll frame it in three ways. And I said this on the steps of the Capitol during one of the rallies at the State House last week. There are three ways that I think folks can show up. We're talking about presence, policy, and power. And so our presence is important. And I like to say that presence shows up before the ballot box. A civic engagement shows up before the ballot box. And so when we are showing up in community, understanding what the needs of our community are, essentially that helps inform, right? So our presence, how we are showing up for people, how we are even getting folks to the polls, what information are we sharing? What kind of conversations are we having to actually inform people? Also, how are you being present in your local communities with the organizations that are already doing that civic engagement work? League of Women Voters, and Kim, I'd like to know, the number has how many chapters statewide? There are ways to tap in. And so we have to be invested. Our presence matters. The next is policy. And I love to talk about this because the ACLU's framework is really talking about the people's house. We have this idea that the state house is something that is so foreign to us. And it is designed for us to think that, but policy shapes our lives. And so it is important that we are holding our elected officials to account, to understand our needs and to show up and to present policy that makes sense. Because oftentimes every legislative session, we are seeing policies that don't make sense. That's a waste of taxpayer dollars. And that really talks about social, cultural issues that are not substantive to progress and who we want to be as Alabamians, that are going to change our life and ultimately the lives of our family members, whether that is, our children, our parents and grandparents, our neighbors, our loved ones. And so I want to name that. And the next is power. Power is critical. And our power is in both our presence and how we show up. It's both in the ways in which we engage. And if we can demonstrate our power writ large, it matters. We have an opportunity to show up and be powerful on May 19th as Alabamians that want something different and very specific for this state. And we also have an opportunity on Saturday, May 16th in Montgomery for a National Day of Action to show up in response to this moment. It is part of a larger movement. To Kim's point, this is long haul work. This is decades long work. Okay. And so the Milligan case came about. I remember I was in those very early conversations. It came about in 2020. We've been working on this case for 5 years now, right? This is decades long. Judge Clement has shared the beneficiary. He's been the beneficiary of policies that happened in his lifetime that shifted this nation. And we cannot forget that. And so we have to understand our power in this moment. And I do not want us to concede it because we are apathetic or we are tired. We have to understand it. We have to harness it. And we have to have the stick-to-itiveness to see it out. And so I want folks to be tapping in locally. I want folks, yes, show up to the polls, but also ensure that they are showing up and civically engaging at their city council meetings, at their district meetings when their state legislator shows up and has a meeting. All of these things are critical. And I want folks to be informed with the right information. And so those are the three things that are my calls to action for folks in this moment. And I think that we have the power. We really, really do. We really have the power to shift things. It's going to take some time. And it's going to take us to stop being afraid and capitulating. And it's going to take collectively all of us.
That's an amazing note to end this conversation on. We can't thank you enough, Kim, Jatan, and Judge, for taking the time not only to educate, but to motivate and mobilize us to move forward in these dark times and shining light in the darkness for us. I want to thank the attendees for taking the time to get informed. And hopefully you've heard the call to action that's clearly been articulated here. We need to vote as though our lives depend on it, because they do. Get involved. I mean, just in the course of the conversation, I heard opportunities. You can through the LDF and perhaps Jatan speak up about ACLU, but I know the LDF. I've served as a poll monitor before. I've been a legal volunteer. If you're big on social media, just share election deadlines. It's important for folks to know when the absentee ballots need to be submitted, if via mail or in person. Go to, and I think somebody dropped it in the Q&A, go to the Secretary of State of Alabama's website and confirm that you're there as a voter, and confirm your polling place. 2030 is just around the corner. Motivate yourself to do census work. It sounds like that's going to be an important thing to do. Vote 411. Kim, you referenced that. LDF and its voter protection line, 866 our vote. If you have any issues on Tuesday, that's the number you should call, 866 our vote. But yes, thank you all. Thank everybody for attending, the panelists, the attendees. Thanks to folks behind the scenes helping with tech, despite my wonkiness and inability to really navigate it successfully. I want to thank them too. They've been excellent and kept things moving in the right direction. Thanks for monitoring the chat. And we hope you all have a great weekend, and we hope to see you at the polls on Tuesday if you haven't already absentee voted. So with that, I'm going to wish you all a good night and God bless.
Good night.